Good morning, everyone. This is Judy Watman, Director of Education for the Pennsylvania Apartment Association, and I'd like to welcome you to the PAA webinar, Delinquent Rents, Do We Evict? Oops. We know this is a difficult time for people in the property management industry as well as in all of our communities. We hope this webinar will bring some clarification on issues that we face as a result of the coronavirus pandemic and resulting changes in our personal and professional lives. Just a little bit of housekeeping for our webinar today. Please type your questions into the Q&A box at the bottom of your screen. We will be answering questions as we go through the slides, and we have reserved some time at the end for additional questions. Steve, can you go to the next slide? Okay. Just a little disclaimer, a bit of housekeeping for our webinar today. Again, please type in your questions in the Q&A box, and we will have time for questions at the end. The disclaimer says the coronavirus crisis is a fluid, dynamic situation. Details are changing rapidly and new information is being learned every day. In addition, most of us are in uncharted waters, so best practices are being written in real time. What we are presenting is our best guidance based on what we know today. Each individual company and manager will need to make their own decision based on their property and business needs. Nothing presented today should be considered legal advice or mandates by PAA or any of the presenters. You should check with your own legal advisors and consultants on what is best for your business. Now let me introduce our speaker. Steve Williams is the Administrative Manager Partner of Cohen, Seglius, Palis, Greenhill, and Furman, and is a member of the firm's Commercial Litigation, Labor and Employment, Energy and Utilities, and Consumer Protection Defense Groups. He concentrates his practice in the areas of commercial and civil litigation, real estate, landlord and tenant law, condominium and homeowner law, employment law, business and corporate law, construction law, and energy law. Please welcome Steve Williams to our webinar. Steve?
Thank you, Judy, and good morning, everybody. I hope everybody is well. I hope all your families are well. This is truly a different time. I continue to refer to it as our new reality because I believe that in many ways, the things that we're dealing with now, the things we're working through now are going to look the same over the next few months, 6 months, maybe 12 to 18 months. So I think we've got some getting used to over the next some period of months. We're going to talk today about more than just evictions. I think there's a lot going on in your properties. I'm hearing an awful lot from my clients, ranging from payments of rent issues to eviction issues to shutting down the facility issues to maintenance issues. So I want to try to touch upon all of that. We don't have a lot of time today, but we'll take the time that we have to answer as many of your questions as possible. So if I don't get to something specifically that you would like to hear, post a question and we'll try to get to it. Let's start first with the property issues. One of the first questions that I got from clients is, well, what can we do? Are we still entitled to operate? Can our rental offices stay open? What about our fitness center? What about our community rooms? What about our playgrounds and our tennis courts? What are we supposed to do when Memorial Day rolls around? We're supposed to be opening the pool. And the general answer to a lot of those questions is pretty much the same. Your operations in general under Governor Wolf's orders should be somewhat bare bones. You have a business to run and you're entitled to do the kinds of things that are necessary to make sure that your businesses operate and they survive. Collecting of rents obviously is something that can continue. Can our rental offices be open? Can our staff be in the rental offices? The answer is yes and no. Generally speaking, the rental offices should be closed to visitors and closed to residents. You're entitled to have staff in the rental office to the extent that they need to conduct business operations that can't be conducted remotely. Collecting rent, processing payments, processing invoice, making payments to vendors, that sort of thing can be done. Do you have to maintain social distancing, of course. I think we've probably all heard that term, and I think it was almost a month ago that I was already sick of the term. But I think it's reality now. So if our offices are going to be open to the extent that our staff are going to be in there working, we still need to maintain that social distancing best practices. The question I received the other day was, what about masks? And the governor has now ordered, and the Department of Health has now ordered, that when you're outside and around people at the grocery store, et cetera, you should be wearing a mask. I think that's a great piece of advice for your rental offices. I think it's naive of any of us to think that anybody is immune. So I think we need to keep all of that stuff in mind. But being in our offices, doing the kinds of business operations that are necessary is important. Fitness centers and community rooms. It's funny, I had a client early on in the process present a problem to me because they have a resident who insisted on continuing to use the fitness room. And every day he was in there, and every day they chased him out. And then he sent nasty letters about how you're in default of the lease and you're not providing the services that you're supposed to be providing to me. Residents, can be difficult sometimes. And, we had to point out to that particular resident that there are half a dozen different provisions in the lease and in the rules and regulations that give us the right to close the facilities whenever we deem it appropriate, and especially in a case where health and safety is important. So I presume that those of you who have fitness rooms have closed them. If you haven't, I suggest that you do. I suspect that you don't have your community rooms being used by your residents at this time. We're getting into some of the more celebration months where you might have residents looking to use those facilities, and you'll need to make your own decisions based on the governor's order and what the status of that is, of whether you're going to allow that to be used. But in general terms, right now, the common facilities should not be open to your residents' use. Maintenance is another issue. Obviously, maintenance is very important to the upkeep of the property, to the safety of the property. From the very beginning, when the governor issued his very first order about life-sustaining businesses, maintenance and construction issues as it relates to the upkeep and the safety of property was always exempt. It's still exempt, so your maintenance personnel should continue to do what needs to be done to preserve the property. That means on the exterior, in the common areas, as well as in the individual units. If there's a problem in an individual unit that needs to be addressed, we can't ignore that. Because obviously protection of the property is one of our biggest goals in this industry. One of the things that I'm hearing a lot of owners doing when it comes to maintenance is pushing on to the tenants some of the things that the tenants can be handling on their own. Switching out of light bulbs. If you have a property where you maintain that as part of your maintenance, that's something that you can push down to the residents so that you minimize the contact between your maintenance staff and the residents. I heard one property manager who distributed a couple of weeks ago plungers to every rental unit. So that if there was a problem with the clogged toilet, the maintenance personnel were not having to go into units to take care of those sorts of things. So, we always talk about maintenance and prioritizing what gets done, what call has to be done before the next call. And I think we're even more so in that process right now, because not only do we have the protection of the property to keep in mind, but we also have the protection of people to keep in mind. And every time one of our maintenance staff comes into contact with the resident, there's a chance there that there's going to be some contamination in one direction or the other. And our ultimate goal is to try to prevent that. The leasing office, as far as rentals, that's a little bit more of a tricky question. Because under the governor's order, all leasing of real estate is supposed to stop. It's not a life-sustaining business. And the last time I looked at his order, it still said that. However, hopefully you're all aware that the apartment association was successful in negotiating, not necessarily a formal exemption from the governor's order, but some qualifications. So leasing operations can continue to the extent that we're putting families into homes where those families need to be urgently put into a home. So what does that mean? If a family is going to be homeless, if you don't move them in, that's obviously urgent. That's an emergency need. If you have the 21-year-old son who's just dying to move out of mom and dad's home, that's probably not a situation that would fall within this exemption. And what's going to be really important for this industry as it relates to the governor is to be able to show him that we're operating in good faith under the negotiation that we have with him. So if we see that there's a lot of leasing activities going on that don't really fall under the urgent need to find housing category, then there could be some issues going forward with the governor. And who knows, maybe we even find that the governor shuts us down a little bit. Communications with others. Let's talk a little bit about that. What do we do when one of our residents reports to us that they have been tested positive? What do we do if one of our maintenance people call in and say, I've tested positive? What do we do if a vendor calls us and says, hey, I've tested positive? There's no specific direction that has come down on when we absolutely must report these things. Now, the general rule is if you have an employee that has tested positive, there's supposed to be a reporting to the Department of Health, and then there's some guidelines in there. But when it comes to our tenants, our maintenance staff, as far as what notices we need to give to tenants, I've seen the gamut of people and how they're handling that. I've heard some property owners saying, if we're not obligated to report, we are absolutely not reporting. Of course, if our maintenance guy calls and says that he's tested positive, he's not coming back to work, but we're not going to go report to all of our residents that we have a maintenance man who tested positive. What about the residents that we know he specifically came in contact with? He was just in, a particular unit doing some repairs. Do we have to notify that resident? And I've heard a lot of different policies from a lot of different property management companies, ranging from as soon as we know there's a positive, regardless of whether it's a resident or maintenance or a vendor, we are going to put out a notice to anybody who potentially came into contact with that person. And I've heard others say we're not putting out notices at all. And I think that one of the problems with this pandemic that we're in is that there are no hard and fast rules. And any of you who have heard me speak about landlord-tenant issues or fair housing in the past, you've heard me say many, many times, there's not really an easy answer, or there's not a black and white answer. And it's even more difficult now because a lot of what's going on in this pandemic is people are just guessing. We're just guessing at what the appropriate notification process is. We're just guessing at who should be notified when there's a positive test. So my philosophy is that if we can do things that are going to prevent us from potentially being sued down the road, then we should be thinking about those things, because obviously we don't want to be caught up in a lawsuit and be a test case ultimately for the industry of what people should have been doing or shouldn't have been doing. You maybe have all heard that Walmart is the first company that's now been sued for wrongful death by a customer whose family member contracted COVID, and it was tied to some action on a Walmart property. I suspect that none of us want to be that first test case for our industry. So while there is not a clear answer on notifications and how we should be doing it, what is clear is we should each have a policy that everybody knows this is how we're handling it, and this is why we're handling it this way. Before I go to the next slide, I see there are a few questions. Let me see if we can address some of these questions.
Steve, there's one question that kind of got put to the side. I said you were going to answer it. What can we do if tenant's lease has ended and they do not leave?
Yeah, so let me put that on hold until we get into the eviction process.
Okay.
Because it's a very difficult question. Let me just run through some of these questions and see which ones are relevant to what we just talked about, what I can come back to. One question is thoughts on tenants not wanting to pay the amenity fee. Look, if you've got a good lease, and it allows you to close down the amenities at your will based on some incidents or some activities. It does not give a tenant a pass on paying the amenity fee. But at the same time, we're all in this together. And if the amenities are not being used for some period of time, do we waive the amenity fee for that period of time or do we not? I think depending on what your lease says and how well your lease is written, you probably don't have to waive it if you don't want to. But again, that's going to be a company by company decision on what works best for them and what makes the most sense with their residents and their resident population. I've got another question. What do we do with tenants that are withholding rent because of repair issues? We are not handling non-emergency maintenance right now. Again, I think the idea of not handling non-emergency maintenance is a good idea at this time. Again, we want to limit the contact that our maintenance staff are having with our residents and vice versa. It does not give a resident the right to deduct rent. It does not give a resident the right to withhold rent. Unless the repair issue goes to the habitability of the unit, then the tenant really has no ability to withhold or refuse to pay rent. So I think we need to take a hard line with tenants who are not paying rent because of that. And I think what we need to recognize is there are a lot of tenants that I'm hearing about that are really taking advantage of this situation and making this COVID-19 pandemic an excuse not to pay rent. You all know your residents, and you all know the residents that traditionally don't pay on time or don't pay at all, and until you take them to an eviction hearing. And I think you're going to see more of that. But I think what we need to do is just send a clear message to the residents that the reason we're not doing non-emergency repairs is because we're trying to avoid contact. We're trying to avoid the spread of this virus. But at the same time, it does not give you the right to withhold rent. And we will pursue our remedies when we're able to. And we'll talk a little bit more about that in a bit. If you don't pay the rent. And I think that's really the best way to handle that one. Another rent issue we'll get to. How do we determine if a leasing prospect is on an emergency situation? Should we still reach out to all leads, or should we only follow up with them if they mention that it's an emergency situation? Look, I think that's a tough one because people who are looking to move into your property, many of them probably are going to say it's urgent, it's an emergency, I have to get in, I have no place else to go, even if that's not the case. So I think that what we need to do to protect the industry is simply document in each situation. We're moving this resident in, and here's why. And how do we know this? Because this is the information the resident gave us. I don't think we need to go too far outside of what we're being told to investigate whether what we're being told is true. If we have reason to believe that a tenant is not being straight with us, and it's truly not an urgent situation, then I think we can push back a little bit. But other than that, I think, there's no harm in moving people in who say that they, are in an urgent situation. With respect to reaching out to leads, I'm not sure that we should be reaching out to everybody at this point. The idea of allowing the leasing operations to continue is truly in those emergency and urgent situations. So I think if we're reaching out to people, it looks like we're trying to create trying to create a situation where we're increasing our revenues and moving people in. So my thought on that one is, I think we wait until we're contacted by a tenant who's on the list or who's a lead and who says to us, I have no place else to go. I think that's the best way to handle that. As far as, and I just lost that one. Here we go. As far as housing families in need, can you complete units that are within 30 days of completion, and have they been pre-leased? Yes, part of the urgent housing issue is that we're allowed to do the turns. We're allowed to, lay the carpet, repaint. We're allowed to get the unit ready for occupancy if it's for somebody who needs to get in. Now, if we're talking about completing units that are within 30 days of completion, if we're talking about new construction, then I think we have to look at it a little bit more closely. Is it truly an urgent situation? And does this potential resident have no place else to go? Because one thing that's still pretty clear is that residential construction is still at a standstill. And the only residential construction that can continue are those units that are substantially complete. And the definition of substantially complete that I've seen is you're ready to apply for the certificate of occupancy. So if we just have a bunch of units that have a lot of work left to do so that we can rent them, then I think the answer is no, you cannot do that work. But if it's a unit that is specifically to house somebody who has no place else to go, then I think that fairly falls within the negotiated exemption that we have with the governor. Is there a form or a link describing what a residential manager should be doing specifically about renting apartments? There's nothing that I've seen. Now, there's an awful lot of good information on National Apartment Association's website. There's an awful lot of good information on the PAA website about COVID-19 and various best practices. I haven't seen anything specifically about protocol for renting apartments. I'm not saying it's not out there, but I would check those websites. What about taking deposits now for future move-ins? I don't see any issue with that. If I were a resident on your waiting list, I might be hesitant to give you a deposit at this point, frankly. But if you have residents looking to move in down the road, I don't see any reason that you can't be taking deposits. I think, whether you ultimately get those move-ins is going to be another question. All right, let me stop with these questions, get to the next screen, and we'll come back to some other questions. If I can manage this. And for some reason, my screen looks like it is frozen. What's going on here? Okay, so there we go. So let's get into some rent issues. I've heard a lot of things from owners, and I've heard everything from I lost my job and I can't pay my rent, or my salary has been reduced and I've got to be careful, what I put my money to I'm simply not able to pay my rent because I've been sick and can't work. And I've also heard a lot of owners come to me and say, what are we supposed to do with the resident who simply says, I'm not paying you and I know you can't touch me? I've heard at least a half a dozen different owners say that they've heard that from their residents. And in many of these cases, as I talk to the clients a little bit more, many of these cases, it's the residents that have always been trouble with paying anyway. So it's not a new scenario that we're dealing with. It's the same people who have always been either slow pays or no pays, and are now just seeing this as an opportunity to take advantage and not pay rent. So can we continue to charge rent? Of course. There's nothing in the governor's order. There's nothing in the Supreme Court's order. There's nothing in, and we're going to talk a little bit about what the Attorney General is doing. There's nothing in the information that he's putting out there that says this is a free pass, that this is a get out of jail free card, that tenants are allowed to not pay their rent. We expect them to pay their rent. Every one of you knows how important it is that residents pay rent, and what happens if the rent isn't paid. We've got mortgages to pay, we've got employees to pay, we've got vendors to pay, we've got taxes to pay, and none of that goes away for us. So we need to keep the residents paying that rent. Can we assess late fees? Can we charge interest? Again, nothing in any of the orders under which we're operating right now that prohibits us from charging late fees, charging interest. If you've got an attorney's fee provision in your lease and you engage your attorney to help with the collection process, there's nothing that prevents you from charging those fees to your resident. More importantly, though, is how do we get through this with residents who truly cannot make the rent payments? And I've seen a lot of things, a lot of different options that owners are putting out there. Some have said that if a resident comes to me and shows me that they've been affected either health-wise or financially by COVID-19, and cannot pay rent, we're going to waive the rent for January. In some cases, I've heard owners say that we're going to forgive the rent for, I'm sorry, not January, for April. We're going to forgive the rent for April. And then we're going to reevaluate on May 1st and see what happens with that. I've heard others, and frankly, kudos to the industry, because most of what I'm hearing from the industry is that the owners and the management companies are being proactive in addressing this problem. They've been proactive in putting together programs to assist the residents, knowing that this assistance is going to be needed. Things like rent deferrals. Don't pay rent on April 1st and we'll split April's rent over the next few months. And in some cases, right out of the gate, we're going to give you a 3-month deferral on rent, and you'll make it up beginning in July. So there are a lot of options that we can do. What question that raises next, though, is what information are we allowed to require that the resident provide us in order for us to determine that they truly need some kind of rent assistance? Are we allowed to ask for a doctor's note? Are we allowed to ask for some kind of medical information? Are we allowed to ask for financial information? Are we allowed to ask for some letter or something from the employer saying that there's been a layoff? Are we allowed to have them or require that they provide us a copy of the confirmation that they've applied for unemployment compensation? And the answer generally to all of those questions is yes. I mean, we are entitled to know that they're in a position where they need the assistance, unless your company is one of the companies I've heard of that is just going to grant assistance whenever anybody asks. So they're not going to push people to prove anything. They're just going to expect that people are going to be above board and be honest. So generally speaking, yes, we can ask for people to show us that they do in fact need this assistance. I had one client who said, well, in every case, we're going to insist on a doctor's note. And I think that might be a little overreaching, because think about most people who are sick are not getting in to see their doctors because, at least up until now, we've all been told, don't go to the doctor, stay home and quarantine. And only call your doctor if you are having a very difficult time breathing. So in a lot of cases, you're going to have residents who aren't going to have the ability to get a doctor's note because they're not going to be able to get in to see their doctor. So I think we just need to keep that kind of stuff in mind when we're talking about what documentation we want from residents. Should we have a written agreement? If we're going to defer rent, or if we're going to abate rent, or if we're going to put them on a payment plan, should we have an agreement with them? I think you should. Because what you're really doing is, for a short term, you're amending the lease terms. And if you amend the lease terms and you don't have a writing, then who's to say that they're not going to come back and say, well, you said I could do this for 6 months, not just 2 months. So I'm a big proponent of having things in writing and having an agreement that clearly specifies what the deferral is, what the abatement is, what the time frame is, what the payment period is. The fact that nothing in this arrangement in any way changes the other terms and conditions of the lease. And I just think that's just a good practice to have. Let me talk about or look at some of these other questions now that we have gotten through the rent. So here's one, and this is one that I've heard a lot. What do you do with a resident who blatantly says, you can't evict me, I'll pay my rent when I damn well please? I've heard that, and I've actually been on the phone with some residents over the past couple of weeks who have said that to me. He said, your client can't do anything to me anyway. What reason do I have to pay the rent? And the truth is that at this moment, there's nothing that we can do about it. We can assess late fees. We can assess interest. We can charge them the attorney's fees that our lease provides if we're getting an attorney involved to deal with the problem. But other than that, our hands are tied, because, as we'll talk about in a few minutes, you can't evict them. You can't lock them out. So really the way to deal with a resident like that is just to simply, put it in the back of your mind. When this is all said and done, this is probably a resident that you're not going to want to renew a lease for. And I've seen a lot of that happening already, where landlord's response to that comment is, fine, here's your non-renewal notice right now. You just know right now that you're not going to be renewed. A lot of people will look at that, and I think residents will look at that and say, well, now that's a retaliatory action. You can't, everybody knows that landlords are not allowed to illegally retaliate against residents. And that's true, but retaliation only applies to a resident who is taking some legal action. So I'm taking an action I'm entitled to take. I'm reporting you to the PHRC because I think you have violated the fair housing rules. You certainly cannot retaliate in that case in non-renewal lease. But a tenant who's simply saying I'm not paying rent because I don't have to is not protected from retaliation. So I think with those residents, you make a determination, that you probably want to get them out as soon as it's practical. How can we handle residents who don't pay their rent who are not personally impacted by COVID-19? For example, they did not lose their job, have been chronic slow pay prior to COVID. So look, I think it's the same thing. And this goes back to what I said earlier. A lot of the residents that you're going to have problems with are the same ones that you've always had problems with. I talked to a client yesterday and I said, just curiously, what did you see with your rent payments for April? Were they down? Was it, as expected? And surprisingly, she told me that their rent was only about 10% off of where it normally would be. So at least for April, this particular property management company saw a pretty insignificant effect. Is that going to change next month when we're another month into this and people have been off work for even longer? Possibly. One of the things that we need to keep in mind, though, is that our residents who lose their job, for example, they're going to be getting unemployment compensation, and they're going to probably be getting the enhanced benefit, which means in many cases, and as an employer, I hear my employees saying this all the time, in many cases, your residents are going to be doing better than if they were working. So in a lot of these cases, there really is not going to be an excuse for not paying rent unless you have a resident who says, hey, my funds are very limited. I don't know what next month is going to have for me. So I've got to really take my funds and I've got to squeeze them and nobody gets paid. But generally speaking, a lot of people who are financially impacted by this are going to have some assistance that's going to help. I heard somebody say the other day, may have been on the national news, that, as tenants, they need to also understand that, many of them are going to be getting $1,200 from the government. And yeah, that's true. But, does that cover even the rent for some of these people? Probably not. So I don't think that tax assistance that a lot of people are going to be getting is really going to help the situation. What if a tenant is offering only a nominal payment over an extended period of time to work out a payment arrangement? Again, what you do as an owner, what you're willing to do is completely up to you. At this point, you're under no order to do anything as far as agreements with residents. So, it's really a matter of what is workable. If you have a resident that just is not going to be able to make the rent payment, then insisting on the rent payment's not going to get you anywhere. So, I think the amount of the payment, how long the extended period of time is going to be to make up the payments is really going to be a function of a case-by-case basis based on that resident's particular circumstance and what financial impact they really are seeing. And it may be very different depending on each resident's situations. Should we change the wording in our late letters? I don't know that you need to change any wording. The fact is that we are still entitled to move forward. And if rent is not being paid, we can still continue to assess those late fees. Let me see if a couple more on rent before we move over to the eviction issues. Here's a good one because I get a lot of this from college properties. We're an off-campus student housing and people are not wanting to pay rent because the university is closed and classes are now virtual. I had one lady call me and said, look, the students who live on campus have been sent home and they've been let out of their campus housing leases. I'm an off-campus, or my son is in off-campus housing, and the landlord is insisting that the lease is going to remain valid. So again, what's happening on the college campus does not direct what happens in the private housing for college students. And what owners do in those situations at this point is really going to be up to them and how they want to handle it. I think at some point we all have to look at this situation and say, what are the chances we're going to collect money anyway, as we're thinking about how to handle some of these issues. But as far as the off-campus student housing not wanting to pay rent, there's really no reason not to, and the fact that the school is closed doesn't give them that reason. Here's one going back to the leasing process. Our entire leasing process is electronic. Can we still conduct business? Again, the actual putting people into houses is supposed to be limited to the urgent and emergency situations. Can we continue to do showings virtually? Sure. If we have that ability, we should continue to do that because we want to keep the interest in the property, of course, and we want to keep the prospects engaged. I had one client call and say, look, we can do a move-in virtually. We can have the keys in a box outside the apartment. Nobody has to be in contact with anybody else. And can we continue to do that? And that's a tough one because you're doing everything that the governor and the Department of Health is suggesting you do by social distancing. You're allowing a business transaction to occur with no contact, so no chance of transmitting this virus. But it's still outside of what the governor has said is urgent and emergency. So I think this falls into that category of if we take advantage of the out that the governor has given us, we may see it taken away. So I would say, even if everything can be done electronically and virtually, if it's not an urgent situation, I would not be putting people in homes at this point, at least not until we hear something more from the governor. And frankly, I'll just throw this out to Judy to pass on to Leah Sailhammer. Maybe this is an issue that we go back to the governor and talk about now and say, this is another option. Can we continue to do this? And maybe we'll see the governor relax that issue for us. But at this point, I think if it's not urgent, we probably should not be doing it. We had one tenant claim she received legal advice stating she only had to show proof that she applied for unemployment. Look, I can't say what your tenants are being told by other people, but I can tell you that there's nothing in any binding form that says that you must accept this information or you cannot accept that information. It's a matter of what you as the owner are willing to do on your properties and for your residents. How does the new leasing allowances change if the property is a HUB subsidized property? The leasing itself doesn't change, as far as I know. We're still under a lease in urgent situations only directive. So the fact that it's a subsidized property wouldn't change that in any way. Now I'll talk a little, when we talk about evictions, there is a difference for subsidized properties that you'll need to know about, and we'll get to that in a couple of minutes. We have a tenant that had a non-renewal prior to this, and it was dated for May 31st. They're now saying they are not moving. They refuse to pay. They refuse to give us the documents needed for a deferral plan. What should we do? Again, my answer to all of your questions of what can we do at this point is there's not a lot we can do. We've got to ride this wave until the eviction ban is lifted before we really have a whole lot that we can do. But certainly if somebody's in the property, whether they're in beyond their termination date or not, they're obligated to pay rent. And you're entitled to collect that rent. And if they're not willing to enter into a payment plan or a deferral plan with you, you just kind of hold that one in your back pocket. And when we're at a point where we can actually exercise some of our remedies, then we go ahead and exercise those remedies. All right, let me jump back into the presentation. And we'll get back to these other questions that we didn't get to yet. If I can get my screen to move forward. All right, so evictions. The eviction ban that was in place through April 3rd, as you probably all know, has been extended to April 30th by the Pennsylvania Supreme Court. So there's nothing that you can do with regard to an eviction. You can't file an eviction complaint. You can't get a hearing date. You can't request an order for possession. You can't schedule a turnover. None of that is happening right now while we're in this ban. I had one client call me and say, can we continue to submit eviction complaints for filing so that we kind of stay in line, we stay in queue, and we're not behind everybody when the courts open. And in that case, their practice was that they prepare the eviction complaints and they mail them into their local district justice with a check. And the fact of the matter is, there's nothing wrong with doing that. There's no ban against that. You just need to know that that letter is going to sit somewhere until the courts open again and they start opening their mail. Whether that means that you get in front of other people or not, I don't know. I'd like to think that they'll take a look at all of the mail as soon as they get in, and they'll start processing these complaints. But I don't know that that's the case. I think the first thing that the courts are going to do when they open up is start looking at the backlog. What eviction cases had already been scheduled that have to now be rescheduled. I think they're going to be doing all of that before they look at new cases. Anybody want to guess what this is going to do to the 7 to 15 day requirement on hearing schedules? I think we're going to see a lot of evictions that are going way beyond that 15 days. So can we mail the complaints in still? We certainly can. I think if you're going to do that, though, once the courts have been open, my suggestion is that you contact the court immediately, confirm that your letter has been received or that the complaint has been received and it's being processed, because there are a lot of companies that I'm talking to that are reporting that mail's not being delivered with any regularity. So there may be a lot of things that are either delayed in the mail or lost in the mail. So until April 30th, according to the Pennsylvania Supreme Court, nothing's happening. There are a couple of other layers here that we have to talk about. Number one, all across the country, there are local municipalities that are also instituting bans on evictions within their municipal lines. The only two municipalities in Pennsylvania that I've heard of so far is the city of Harrisburg and the city of Philadelphia. I question what powers either of those two mayors or any municipal official has to put a ban on evictions, because evictions are in the sole domain of the courts. So I don't know that legally they have the right to put those bans into place, and I don't know what effect they really would have on you once the Supreme Court lifts the eviction ban. I will caution, however, that if you're in a municipality where you're required to have a license in order to lease your properties, then their ability to ban you from filing eviction cases could be tied to their licensing power over you. So in those jurisdictions that have licensing in ordinances, I'd be careful about ignoring a local municipal official's ban on evictions, because I wouldn't want to see any of you having problems when that license either comes up for renewal or seeing potentially a revoking of the license. I haven't seen that as being all that widespread. There are a handful of municipalities across the country that have done it, and like I said, only two in Pennsylvania that I've heard of so far. The third level that we've got here is the CARE Act that President Trump signed about 2 weeks ago. And the CARE Act puts into place a specific moratorium on evictions of 120 days, and that runs through July 27th. So if we assume that the Pennsylvania Supreme Court lifts its ban on April 30th, and I'm not convinced that's going to happen, but if it does, and you're a property that falls under the CARES Act, then you're still going to have a ban until July 27th before you can file an eviction case. So what is the CARE Act coverage? It's fairly simple, and I can summarize it like this. If you get federal dollars, you fall under the CARES Act. If your tenants participate in the voucher programs, if you're a covered property under the Violence Against Women Act or the Housing Act, if your mortgage is Fannie Mae, Freddie Mac, HUD, federally backed in any way, then your property falls within the CARE Act. And in that case, you cannot expect evictions until July 27th. Now, the CARE Act provides an additional problem, and that is that that you cannot issue late notices, you cannot assess late fees, you cannot assess interest charges, and you also cannot issue notices to vacate or notices of non-renewal for an additional 30 days. So the effect of all of this really is that if you're just starting the process and you haven't yet issued those notices, then those notices can't be issued until August 27th or so, and I might be off a day or two, but with the math. But late August is when those notices can be sent. If you're already in the midst of an eviction that's been stayed as a result of the pandemic, once the stay is lifted in the state under the CARES Act, you're still stuck until July 27th before you can either file that complaint or get a hearing or get anybody dispossessed. So the real problem here is that, take an example, an extreme example that one of my clients called me about the other day. They have a resident who didn't pay rent in February. So they filed the eviction complaint. The eviction complaint, they didn't pay rent in March. The eviction complaint is now stayed. They haven't paid rent in April. They're not going to pay rent in May or June. July rolls around. They can finally proceed with that eviction. It's probably going to be another 30 days till they get a hearing. So that's now August. September at the earliest that you can actually get this person out. So now you have somebody that's been in the property from February through September, hasn't paid a penny in rent. Now you can get them out, but chances are you're never going to see that rent from this person. So that's going to be a problem for the federally insured and federally affected projects. And there's just nothing that we can do about that. There's been some talk, very, very vague, high-level talk about maybe some additional assistance that might be directed toward landlords who fall into this hole, but that remains to be seen. So 3 levels: state Supreme Court ban, 30 days, but you can do anything you want during those 30 days to tee up the eviction. Then you've got the local municipal issue of the ban. Again, nothing in those bans that I've seen that prevents you from teeing up a case for an eviction once the ban gets lifted. If you fall under the CARES Act, you really can't do anything during the period of time that the ban is in effect through July and August of this year. So those are the 3 real hurdles of actual bans. Then we've got a 4th hurdle in Pennsylvania, and that is our Attorney General. The Attorney General has come out and suggested, he sent a letter to the Apartment Association and a bunch of other organizations and big property management companies, in essence, saying that landlords should go above and beyond and recognize that this is a difficult time for everybody. I want to just read a couple of sentences from his letter because it really gives you a sense of where he's coming from. He says, with millions of Americans or millions of Pennsylvanians following Governor Wolf's direction to stay home, it is critical that rental evictions cease for the duration of this emergency. Hundreds of thousands of Pennsylvanians have lost wages and jobs during this crisis, and we will need time for businesses to reopen and for our economy to come back when the emergency is lifted. Stable housing is a part of the foundation we need as a Commonwealth to fully recover. What he is now saying is that there should be an additional 60-day moratorium on evictions. And he's got, if you look on the Attorney General's website, he's got a program, and I'm losing the name of it right now, that talks about this. And the question is, what authority does the Attorney General have to tell us that we can't evict people? If the Supreme Court lifts the ban on May 1st, what authority does the Attorney General have to say we still can't, or we have to wait another 60 days? The simple answer is he doesn't. He has no authority. He's got no jurisdiction. He's got no power. What he does have, and what concerns me, and I've expressed it to many of you as we've talked, he has the power of the Consumer Protection Statute. And he already has his sights on this industry, and I've been battling for a couple of years now many cases that he's filed against industry members for any number of reasons. He's got his ideas of how this industry should operate without regard to what the law says we can and can't do. And when we don't operate within the confines of what he thinks we should be doing, he tends to issue subpoenas, he tends to start investigations, and in some cases starts prosecutions. So my concern that I'll share with you is, although the Supreme Court's order allows us to continue the process of getting ready to file evictions, it allows us to send non-renewal notices, allows us to serve eviction notices, notices to quit, allows us to put somebody into a holdover rent if their lease term has ended. I'm concerned that the Attorney General is going to look at those situations and say that those are consumer protection issues and start investigations and possibly prosecutions. So I think as you're asking yourselves, how are we going to continue to operate during this ban? What are we going to do? Are we going to assess these late fees? You have to keep in the back of your mind the Attorney General and what, if anything, may come of it with that. I had a few clients send to me their proposals. This is what our plan is. We're going to give rent abatement. We're going to rent deferrals. We're going to have payment plans. We're going to allow people this flexibility. And I think if you have those kinds of plans in place, then I think if the Attorney General looks at you, it's going to look better for you that you have those kinds of things in place. Had one client say, look, why should I stop the process against a guy who hasn't paid his rent since November? I don't think this is a guy the Attorney General is going to really protect with a consumer protection claim. But I think what we're going to see, I fear what we're going to see in the wake of all of this is a lot of Attorney General consumer protection complaints and potentially some investigations and prosecutions. So we just need to keep all of that in mind when we're talking about what we're entitled to be doing under the Supreme Court ban, and maybe trying to distinguish that from what maybe we should be doing, again, to set ourselves up to be in the best position that we can. I want to go to the last slide before we go to the questions, only because there's not a whole lot to say. But we can't really talk about disease without talking about fair housing implications. So the question really is, as any of you who have heard me talk about fair housing, the first question we always have to ask is it a disability? If it's not, we just end the inquiry. If it is, then we have to talk about accommodations. So is COVID-19 a disability? Well, the answer is I don't know. A disability is a very fluid thing. And a condition that I have may not be a disability for me, but that very condition for somebody else might be a disability. So if we have somebody coming to us saying, you have to give me an accommodation on my rent because I have COVID-19, then I think we treat it like any other fair housing issue. Is this a disability? You must show me that you are disabled before I have to talk about any kind of accommodations. And we treat it like any other disability, whether it's a sight disability, a mobility disability, anything like that. So I think nothing really changes under fair housing. And I think probably in most cases, COVID-19 is not going to be deemed a disability because most people are not going to have significant symptoms. Most people are going to recover fairly quickly. So in most cases, it won't be, but I don't think we can dismiss the disability question because for some people, it could very well be a disability, and we need to keep that in mind. So let's go back up to the questions. I think what I'm going to do, I'm just going to go back to the top of the list. We're going to run through these. And Judy, unless you have a different thought, I know we're running low on time. I'll just keep going. And if anybody wants to stay on the line, I'll go as long as we have these questions. Is that okay?
I think that's fine.
Okay. All right. So then I'm just going to run through these. When we're done the questions, we'll end the seminar. So thoughts on an employee who thinks that he might have the virus. Look, anybody who's showing symptoms should be sent home immediately if they're there. If they're not, if they're already home, they should be told to stay home. They should be quarantining themselves for the 14 days, and they should not, under any circumstances, be coming back to work. It's really that simple. We haven't really gotten to the point yet where everybody who wants to be tested can be tested. We're still reserving the test for people who are significantly ill. So, it may not be that we really have the ability to weed these out very easily. So until something changes, until there's some different direction from the Department of Health, you have somebody who is exhibiting symptoms, you treat them as if they have it, they stay home and get better. For those not in an immediate need of housing, should we not be offering self-guided tours at this time? In some instances, does this require an employee to be present to allow access? I think the only tours that we should be offering at this time are tours of virtual nature. They can go on your website and they can tour that way. But on-site tours, we should not be allowing at all. I think to say that we can do it without having an employee have to be present misses the point. Because we can't control who's in that model at the same time. There could be 5 or 6 people that show up at the same time, and then that's going to be a problem. So I would say virtual tours at this point is the only way that we should be going. We addressed that one. What if you got the eviction before the lock through, but the court shut down before I could get a constable to do the immediate eviction? Once the court's open, can I get a constable and follow through with the eviction? That's going to have to be seen. I'm not sure how that's going to operate. My guess is that if you already had an eviction date scheduled, then it's simply going to be contacting the constable and getting that rescheduled. So, and depending on the time frame, some of these district judges may say that you've got to refile your request for order for possession, especially if we get beyond the 60 days or the 120 days. I don't think that's the right answer, because under the court's order, all deadlines are stayed. So that shouldn't happen, but that may happen for some cases. But I think if you've already got that date scheduled and then it got pushed off, you just reach out to the constable, or through the DJ if in your district you do everything through the DJ. But it should be that simple. There's going to be delays, of course, but the process should be that simple, I'm guessing. If a vendor, tenant, employee tests positive, and you set up to us, if we let others know they are in contact, does this fall under HIPAA? Yeah, so HIPAA's an interesting animal. It does not have the broad stroke application that many people think it does. HIPAA generally provides that medical personnel and employers who have medical information are not to reveal that information. If a tenant comes to you and says, I tested positive, I don't believe it's a HIPAA violation if you tell everybody in the world that this tenant tested positive. I don't suggest you do that. I don't think it's a good idea. I don't think you need to. If somebody is tested positive and you want to put that notice out to people, I think the best way to do it is to simply say, one of the residents in your building has tested positive, and here's all the stuff that we're doing in an attempt to avoid the spread of the virus. One of our vendors who was on the property last week has tested positive, those sorts of things, but you're not going to identify who the person is. Now, if you know that that person specifically came into contact with other people, then the next question is, do I contact those other people specifically and say, look, I gave that general notice that somebody was on the site who tested positive. I'm not telling you that I have reason to believe that you came in direct contact with that person. That's a decision that you each need to make on how far down you're going to give the notice. But in any case, there's no reason to identify by name who the person is. And I think if you just keep it at that, I'm not telling you who it is. I can't give you any more information. I'm simply telling you I have reason to believe you came in direct contact. Then that would certainly fulfill I say obligation, although it's not a legal obligation, but that would fulfill the notice requirement as I see it. How should a landlord respond to a property manager who decides not to work in the office? Well, look, there's nothing in any of this that says that employees can just decide not to come to work. Look, as an employer, if I have employees who are afraid to come to work because of this virus, especially if they're either high risk or if they have family members who are high risk, I'm going to find a way not to require them to come to the office. If they're performing a job that other people can perform, we can do it that way. If they can perform their job remotely, we can do it that way. If they're performing a job that only they can perform and it has to be performed on site and there's no other alternative, then I guess in that case you're going to have the person come. Is it a terminable offense? It could be. Nothing in all of this says that you can't terminate somebody who refuses to come to the office. Are they going to be entitled to workers or unemployment comp? Probably. I think in those cases, probably. But somebody who is off work because they're fearful of coming to work probably does not fall under the CARES Act sick leave policies. And I hope nobody asks me any specific questions about that because I'm not up on that as well as others. But generally speaking, if you have somebody who's saying, I'm not coming to work anymore, you're not obligated to keep them on the payroll. It's that simple. If a broken washer or is a broken washer or dryer considered a repair that affects the habitability of the apartment? Each unit has its own washer and dryer. Um, I don't believe it does. At last look, laundromats were considered life sustaining, so they're still open. So worst case scenario, somebody could go, there. So I think that's probably one of those gray areas. I don't think it affects habitability. And the residents do have the ability to get laundry done elsewhere if they need to. So I would not say that that's an emergency that you would have to take care of. Now, if you have a situation where your residents are not there, maybe they're gone for a few weeks, maybe they're down at their shore house and they're not coming back until all of this passes, but they call you and say, look, while we're out, can you take care of that? I don't think there's any risk in doing it that way. But certainly if people are still living in the apartment, I would not consider that an issue of habitability. If you're working at a lease up that will not be finished until midsummer, should we not respond to those leads? No, I think you can keep work in progress going. The only ban that we have right now is that we're not supposed to be actually putting people into homes unless it's an emergency or urgent situation. So, continue working those leads, continue processing the paperwork to the extent that you can get the background checks done and the criminal checks and all that. I mean, everything's going to be slowed down, but to the extent that you can do all of that, then I would say keep doing it. Just be mindful of the fact that if this gets pushed out further, those leads that you're working on right now may not actually be able to move in. Hopefully by midsummer, we're not looking at the same situation, but that's okay. Next one, looks like I misstated about new construction. The definition on the PA government website states it's not ready for certificate of occupancy. Units with a certificate of occupancy, which is impossible because you can't get one without the unit being complete. When I saw that, that was my question also. If it's not complete, you're not going to get the CO. So how can you continue working on something under that substantial completion definition? The other problem from a construction standpoint, frankly, is that even if you're in one of the construction areas that's allowed to continue, like healthcare and the Department of Defense kind of construction, and now utility work is picking up again, there's still a problem with getting inspections done and getting permits issued. So that's going to continue to be a problem. If new leases want to cancel their move-in because their job start date was pushed back, would you let them cancel and keep the deposit if we have one, or only offer to push the move-in date back? Look, I think you do. You really need to. That's a case-by-case basis. But if you're going to let them cancel, question whether you're entitled. And when you say keep the deposit, I'm presuming you're talking about the prepaid security deposit. Keep in mind that under Pennsylvania law, you cannot keep the security deposit unless you have charges against which you can apply it. So in this case, you say, look, we're going to cancel, but you've got to go through the cancellation provision in the lease. Then you can probably take the deposit and apply it to the cancellation fees. But if you have, for example, an applicant who has not yet signed a lease, in that case, you would not be able to keep the security deposit. Let's see what's next here. All right, well, somebody, I hope you haven't already jumped off. I have to jump off early. Will this webinar be available online to listen to later? Yes, it's being recorded and it will be available on the PAA website. As a landlord, are we allowed to ask for proof that a tenant cannot pay? I think we covered that. Yes. The extent to what kind of information you're going to ask for really is just a matter of comfort from you. The only caution that I give you is if you're going to require that they provide you information that they can only get from somebody else, that practically might be difficult, especially if it's medical information, because they're not going to be able to get in to see a doctor more than likely. But yes, in general, the information that you want to require, you're probably going to be able to require. What if someone was sent a non-renewal notice in December for the end of April move out? Their apartment has been re-rented. Are we still okay to move forward with that? Well, let's assume that they actually move out first, because what I'm seeing is a lot of people who have April 30th move outs are telling their landlords now they're not going to be moving out. So you might have that problem initially, in which case, there's not much you can do about it. If they do in fact move out, are we okay to continue with the re-rental? Again, if it falls under the urgent or emergency category, then the answer is yes. If it doesn't, then you shouldn't be. And again, what's an emergency? What's an urgent situation? Is going to be it's in the eye of the beholder. So you just need to evaluate those situations, and if you can make a determination, I like to say, if you can apply the straight face test. In other words, if you're looking at a judge or a jury, and you need to say it was an urgent situation, if you can say it with a straight face, then you're probably okay to move forward with it. Next, we are having an issue with completing written agreements. Tenants don't really know at this time when pay will start coming in due to backlog of unemployment, unsure of stimulus. Makes it difficult to complete a written plan, and they are hesitant to agree because we don't know the length of this and when help is coming. Best suggestions for this? Look, I think that's a very real problem, and I think the best way to handle that is to simply say to the residents, look, we need to get something down now. We will work with you if this becomes a plan that is not capable of being performed, but we can't just sit back indefinitely with no rent coming in. That's not acceptable. We've got to have a plan in place. We'll be flexible if we need to be flexible down the road. Other than that, I'm not sure what else to do because, again, we don't have the eviction hammer in place at this point, so we can't hold that over their head. Can we report non-payment to credit agencies during this period? If yes, can we do it at a property that has a Freddie Fannie loan? If yes, so look, I think this falls under the Attorney General category that I talked about before. Forget about Freddie or Fannie at the moment. If you're purely a market property and you have the ability to still report to credit agencies, there's nothing that prevents you from doing that. If you're a Freddie or Fannie or you fall under the CARES Act, I would say probably no, although that's not specified in the CARES Act. But I would say that that's probably an action that you can't be taken. Where I say it falls under the Attorney General is, his position is everybody's going to need a break. Everybody's going to have to be flexible. Everybody's going to have to be patient. We're going to have to work with each other to get everybody back up and running. And by reporting things to credit agencies, you're kind of blunting that process. So I would say that, my prediction is that the Attorney General probably would say you should not be doing that. Again, he's got no authority, no jurisdiction to tell you can't. But if you're going to, I would do it with the backdrop of, he may be looking over your shoulder one day and taking a look at what you did, and will you be able to justify that? Just heard that we can accept emergency situations. How does that affect the waiting list? HUD tells us we cannot do that. All right, so yeah, forget HUD for a second. Let's talk about market properties. If you've got a waiting list, but the people are not emergencies, then emergency tenants are going to trump them. That's just the way the process works right now, because we can't just take people off the waiting list right now. The rule that HUD says you can't do it is going to trump that. So in that case, I'm not sure what the easy answer to that is, because under the governor's order, you can't simply rent to somebody because they're on a waiting list if it's not an urgent situation. And if you have somebody coming in who's an urgent resident, my guess is that you probably just can't rent at all in that situation. But again, a lot of what we're doing here is guessing, because we just don't know how a lot of this is going to pan out ultimately. But that would be my guess about how that one's going to work. My resident isn't responding to my attempts to work out a payment plan. What are my options? Again, I think when you have the tenants that just simply aren't going to work with you, or aren't going to talk about this, they're not going to deal with you, I think you put them on the list of non-renewals. Maybe you send the non-renewal notice now to get their attention, even if it's not the time now when you would normally be sending a non-renewal. Send the notice to vacate, send the default notice. I'd use all of the arrows in your quill that you have, when tenants aren't paying. I wouldn't be terribly concerned about the Attorney General impact that I've been talking about if it's a resident who's not saying, this is why I can't pay, this is why I'm not talking to you. But if it's just somebody who's just not being responsive at all, I think you're probably okay to move forward in those aggressive steps. Let's see here. Even though we can't evict, can we send out late notices? Again, yes, unless you are falling under the CARES Act, then late notices and late fee assessments is not something that you can be doing at this point. Yeah, so here's one for people that were sent non-renewals prior to COVID. They refused to move out. Can we charge the holdover rate? Yeah, look, nothing in what's going on right now says that residents can unilaterally extend their lease terms. So if they're now in the holdover period, you can assess the holdover rent against them. And again, the only caution that I have with that is whether that's something that the Attorney General is going to look at and say you shouldn't have done, and maybe start a consumer protection matter. But other than that, then yes, that's how I would handle that. Can PAA provide written document to members of the governor's exemption relating to leasing? That's actually on the PAA website. I don't have, it's going to be under the COVID section.
Yeah, if you go to the coronavirus section of the website, there's a number of resources on there for people to refer to.
Yeah, and that is there. It's a chart that shows, in essence, what can continue. Have I done any forbearance agreements, and what do they look like? Yeah, I've done a number of them, and look, they're fairly simple. You've got a couple of components. Number one, you have a tenant acknowledging that rent is due in the amount of X dollars. You have an acknowledgement that they're having difficulties because of the current situation and they need some flexibility. And then you have, what that flexibility looks like. Is it a rent abatement for a month? Is it a deferral and it's going to be paid, over the next 5 months? Is it a deferral but it's got to be paid on May 1st? Whatever those terms are. And then just a basic statement that nothing changes the lease terms, and this is just a forbearance on rent only. There's not a lot of magic to it. You want to make sure you have the right language. You want to make sure that you don't have a resident that can look to it 6 months down the road and say, I'm allowed to continue with forbearing. But yeah, I think we're going to be seeing a lot more of those. What's acceptable proof for those who say their hours have been cut back? Do we ask for a letter from HR or direct supervisor? Look, I think it's fair game to ask for that kind of stuff. And if you can get it, that's great. I think, I can talk for my HR director for my firm. She's very busy and she's not going to have the time to issue those kinds of letters for employees that need it. And I think you may find that a lot of your tenants are in the same boat. But to the extent that you can get something like that, that's great. To the extent that you just have to rely on the tenant saying that this is the case, that may be the case in a lot of situations. If we have a unit already rented for a future date and the current resident who gave notice is now refusing to leave, what options do we have for both parties? Well, I think the first thing you need to do is let the current resident know that, it's been re-rented and staying beyond the end date is not acceptable. And to the extent that you do, you're going to be in holdover, and the remedies for holdover are as follows. The rent goes up. You're also responsible for any claims that the new party assesses against us. If that person has to go live in a motel for 30 days, we're passing that cost on to you. It's really at this point, what options we have at this point is really just talking to residents and letting them know what the potential consequences are for their actions. And hoping that gets us somewhere and gets some movement. In some cases it may, in many cases it won't. Back to rewording late fee letters. These letters are 10-day letters. If tenant does not pay in 10 days, they are entitled to file. We're not actually entitled to file. I don't know that I need to change that language. If you want to change the language, you could just simply say, well, no, because you're not saying you're going to file in 10 days. So I don't know that I would change the letters unless your letters specifically say that if you don't pay, we will file on the 11th day. Maybe you change that just because the tenant reads it and knows you can't do it anyway. But generally speaking, I don't know that most of the late letter notice or wording needs to be changed. Can you review again the July 27th date versus the August 27th date? Let me pull that back up. So the moratorium on evictions that goes until July 27th. So that prohibits anybody from making, causing to be made, or filing any legal action to recover possession of a dwelling for non-payment of rent or other fees or charges. So I didn't say that part earlier. The CARES Act moratorium only applies in non-payment of rent issues. So if you're looking to evict somebody for some other reason, the moratorium does not impact you. And in that case, you would just be limited by whatever the state moratorium is at this point, April 30th. The August 27th date is a little different. What the August 27th date is, it says until August 27th, a landlord may not require a tenant to vacate here's what it says. A landlord may not require a tenant to vacate sooner than 30 days after the date notice is provided. So you provide notice that you have to leave. That notice has to give them at least 30 days, but that 30th day cannot be sooner than August 27th. All right. Can you go back to the notice regarding positive testing of COVID? What do we do so we're not sued? So look, I think having a policy in place that is followed is the most important thing. If you're going to have a policy that you're going to provide notices, it should just be a very clear policy on in what cases you're going to give notices, to whom you're going to give notices, how are the notices going to be given, and what information is going to be given. And then you just need to follow those policies where people are going to get sued, in my opinion, and we've already seen one. Walmart's been sued. And I think that the whole COVID-19 is going to create a little cottage industry for plaintiffs' lawyers who are going to be suing people. You're going to be sued for one of two reasons. Number one, you were required to provide notice and you didn't. Or your policy is that you're going to provide notice and you didn't follow your own policy. So in the cases where you're required to provide notice, as far as I know at this point, and the most recent I've seen is that only applies if you have an employee who tested positive, that you're supposed to be reporting that to Department of Health. With regard to your tenants, there's nothing that I'm aware of that says you have to report. So it's really a matter of whether, as a matter of policy, you're going to report, and then to whom and under what circumstances. So what's important is having that policy in place. And just making sure that the people in your organization are following that policy. Did you say you can't send late notice under the CARES Act, even if the notice doesn't include late fees or interest? No, you can certainly send a notice under the CARES Act that rent hasn't been paid, but what you can't do is assess late fees or interest because of that. How does the Attorney General expect us to pay our property taxes? Look, that's an awesome question. I've seen a couple of articles through LinkedIn, one that Greg Brown from NAA pushed out. He didn't write it, but he pushed it out. And then another one from somebody else in the industry talking about this whole rent idea and the idea that if the rent is not paid, it just means that the owners are not going to have that third car that they want. And the idea that landlords are just sitting back collecting tons of money. And both of these articles were written very well that talked about all of the places where rent money goes, taxes, salaries, upkeep on the property, those sorts of things. So look, how does the attorney expect us to pay? I just don't think in many cases, either the Attorney General or some of our legislators or the governor or Department of Health are really considering the entire impact on the industry and on the economy as a whole when they're instituting these various bans. And I'll give you a simple example. One of my clients got an exemption to continue working. He's a manufacturer, and he got an exemption because a lot of the work he does is for medical facilities. So he gets an exemption, but he can't get any materials because the people that deliver his materials are not exempt, the people that manufacture his materials are not exempt, and it goes down the road. So he's got a situation where he's allowed to continue operating, but he can't because none of these other people that are required to do something before he can manufacture can do their work. And so the process that we're seeing is that we're starting to go through a lot of this analysis and things are starting to be lifted a little bit. So that, if you're an exempt entity, for example, the entities that feed you are also going to have some level of exemption so that they can feed you. But yeah, I mean, it's a tough question. Can I share the AG letter with the group? Judy, do you know if Josh Shapiro's letter is on the website?
I don't know, but I have that on my list, and I will talk to our legal people about posting that.
Okay, all right. And tell you, as I was looking through my papers, I just missed one thing that I wanted to cover before we get back into these questions. On Monday, the Secretary of Health, Levine, issued an order regarding building safety measures. And in essence, what she said was that proper cleaning and disinfecting of buildings is vital. And for certain buildings, commercial buildings of more than 50,000 square feet, covering all kinds of industries, and residential buildings with at least 50 units are now obligated to put into place certain cleaning protocols. Number one, to the extent that they had cleaning in place before any of this, they're required to continue that. In addition, they have to have a protocol in place to regularly clean and disinfect the high touch areas like the doorknobs and things like that, light switches. And to the extent that they have security employees who, before all of this, were used to control, maintain order, control crowd access, control access to buildings and all, you need to maintain a sufficient number of those security personnel to make sure that that purpose is still being served. It came out, I don't know if it came out Monday or if it came out Sunday. It was effective 12 a.m. on Monday morning. And the penalties for noncompliance are fines of up to $500, or the Department of Health or somebody at its direction can come into your properties and do all of this for you and pass all of the costs on to you. And as probably every one of you are thinking, you can do it a lot cheaper than the government's going to be able to do it. So better just to keep in mind. A couple of questions that came up with this is, okay, so what if we have 10 buildings on our property, but not a single building has 50 units? Maybe we have 10 buildings and they all have 30 units. Does this order apply to us? Well, it doesn't apply under its clear words. It only applies to residential buildings with at least 50 units. So I think if you're a community that doesn't have a single building with 50 units, then I don't think it applies to you. What's not clear, though, is if you're a community that has residential buildings with at least 50 units, does it also apply to your common areas? And the order doesn't specify, but my suggestion is that it probably does. And if the question comes up, she will clarify it and say, of course, that's what we intended. So if you fall under that 50 unit or bigger building category, you probably should apply these cleaning protocols also to your common areas. All right, back into these questions. We still have quite a few. I'm happy to stay on until Judy tells me that's enough. What if we have an eviction that was already moved out and all we are waiting to do is file for possession? Are we able to do this at the end of April, or do we have to wait? Well, again, it's going to depend on what your district justice court and constable are going to do. I hope and I have to expect that they are all already talking about protocols and what are we going to do when the doors open, how are we going to handle these things. But yeah, assuming the ban is lifted on April 30th and you don't fall under the CARES Act, you should be able to just get that order for possession issued and get the constable to schedule the turnover date. And again, the only issue there is whether the Attorney General is going to do anything because you didn't wait an additional 60 days. But certainly legally, you would not have to wait that 60 days that the Attorney General is requesting. Can we still assess non-sufficient funds if the property falls under the CARES Act? The Act does not specify non-sufficient funds, but it says you cannot assess late fees and other charges in connection with the non-paid rent. So I would put that in that category. If you have a check that bounces, you in essence have rent that hasn't been paid. I would say the non-sufficient funds fee falls under that prohibition as well. All right, here's a long one. Let me see if I can work through this. Thought to ponder about relating to the question doing virtual remote leasing. In the frequently asked questions, it does say under question 37, only emergency housing and emergency maintenance qualify as life-sustaining services. Virtual and telework operations must be primary option when available. In-person work at a business site is only to be performed in the most limited basis possible to deliver the services or goods of a life-sustaining business. Would you think the second sentence would allow for remote leasing activity as the one question asked? No, look, I think it's all going to come down to the question of you're putting somebody in the unit and is that an urgent or emergency situation? If it is, then you're entitled to do the kinds of things that need to be done to get that person in. Do you still have to exercise social distancing and the other best practices to avoid contaminating and spreading the virus? Absolutely. But if it doesn't fall under life sustaining, then I don't think we even have a question, because we shouldn't be doing it at all. All right, next question. The city of Bethlehem canceled all inspections, but told us to just keep a list of units that need to be inspected, and they'll come out within 30 days once this is all over. All right, well, that's interesting. I'm just happy to hear that there's actually a municipality that's actually doing the inspections, because I hear more often than not that municipalities actually don't do those inspections. How do I handle a tenant who claims not to have the ability to dispose of trash properly due to COVID-19? For example, placing trash outside their apartment and disposing of it later. Look, there's nothing that prevents somebody from going out of their unit. There's nothing that prevents them from walking to the trash dumpster. If they're too sick to actually get out of bed, that's one thing. But I'm having a hard time thinking of an example where it would be appropriate to simply say, because of COVID, I'm just going to put it outside my apartment and dispose of it later. First of all, that potentially creates a health hazard of its own. And what I know of the Secretary of Health in Pennsylvania is, while she's willing to prioritize health situations, she's not going to trade one for the other. So, we're not going to allow a health situation to arise simply because somebody's afraid. If this is a resident who's simply afraid of going outside, then I think the response is, you're just going to have to do it. It's that simple. For Freddie mortgages, are we allowed to evict after May 1st so long as we don't enter into a forbearance agreement? No, evictions under Freddie mortgages, you're not going to be able to evict until after that July 27th deadline passes. If the new tenant's old lease is up at the current location, would that be considered urgent? Good question. In Pennsylvania, where a landlord's not allowed to do lockouts and not allowed to do self-help, I think the mere fact that their old lease is coming up probably does not create an urgent situation. A lot of factors to consider. If that unit is already rented, and if the new person coming in is going to be homeless, then I think we can look at the situation as a whole and say that the situation is an urgent situation, and therefore the current tenant can move out. But I think what's urgent and what's not really is going to have to be looked at on a case-by-case basis, and even the slightest of fact may change the answer depending on what we're looking at. Are we federally funded on evictions or just restricted to non-payment of rent, or can we proceed with termination for material non-compliance? So yes, under the CARES Act, the restriction on evictions through July 27th is only for non-payment issues. So once the Pennsylvania ban on evictions is lifted, the CARES Act prohibition will not prevent you from evicting somebody if it's based on a non-payment or based on a non-rent issue. Non-compliance with lease, end of lease term, non-renewal, those sorts of things under the CARES Act would not be prohibited. The Attorney General banned for 60 days. Does that mean that the resident must be 60 days behind in rent or just another 60 days? It's not clear. He simply says a moratorium of 60 days. But based on the letter that he sent and his idea that people are going to need some time to get back on their feet, I believe he's suggesting that after the ban is lifted, we should still give them an additional 60 days. That's my reading of it, but I haven't seen anything definitive on that. Talked about that. We talked about that. Same question. Residents in a wheelchair, is a broken washer dryer considered a repair that affects habitability of the unit? Look, keep in mind your decision of whether or not to do maintenance on a particular unit is really a decision that you make. There's nothing that says that you cannot continue to maintain routine maintenance. But if your decision is that we're going to hesitate to do maintenance that's not necessary, that's not habitability, then I think you look at the situation as a whole. Broken washer and dryer, probably not a habitability issue. But if the residents in a wheelchair can't get out of the unit or can't effectively get to a laundromat, then that may be a factor that you weigh in determining that in this case, we're going to take care of it. Again, every case is going to really turn on the specific facts. We talked about late notices under the CARE Act if we're not actually assessing rent. If most or all work can be completed remotely, should you be required to work on site in the office? Look, I think the general rule, the general hope of the governor is if you don't have to be there, you shouldn't be. You know, if even with life-sustaining businesses, to the extent that work can be done remotely, the encouragement is that it should be done remotely. So I would say that your office should be open only to the extent that somebody needs to be there to complete something. So maybe somebody goes in, I can tell you how my office operates, 2 or 3 times a week, somebody runs in there, grabs the mail and gets out. Nothing else needs to be done in the office. So if all of your rent, for example, is paid electronically, and it's just a matter of mail, maybe you could have your mail service routed to the property manager's residence. But things that can be done remotely should be. Should we continue our annual recertifications? Wow, you know, I that's a question that I would probably ask the housing authority, how they're handling those, what is expected, because I don't know the answer to that, but I would get direction from them on to what extent that has to continue to happen. When needed to make immediate repairs in a unit, what can we do if a tenant denies the landlord entry? Well, look, there's nothing different in this situation. If you've got an emergency repair that has to be done, you know, you've got water coming through the ceiling of the unit below, you've got to get in that unit. You know, the situation's no different, except that you have tenants now who maybe are less likely to let you in. And really, you know, you're allowed to break and enter. You're allowed to key in if you can. If you've got a resident who's standing at the door with a gun, or a billy club or a bat, you know, we're certainly not going to put ourselves in a position of emergent or of danger. If the repair can be done, in the case of a leak, if the repair can be done from the apartment below, maybe that's what you have to do. But again, you know, the situation, you know, what your ability is in this case is no different than when we're outside of this COVID situation. We executed a lease that's begin on June 1st. The person will not have a place to live if the apartment is not available on June 1st. What do we do if the current tenant stays? We can't make him leave beyond his lease of May 31st. Well, the question's presuming that the eviction ban continues beyond beyond April 30th. Yeah, look, it's a real problem. If you don't have the legal ability to get that current tenant out, then you have no ability to put the new tenant in. And what that means is that new tenant is either going to find someplace else to live temporarily, or is going to go to a different community, and you're going to lose that resident. In those cases, if your lease is well written, you could certainly charge to the current tenant the losses that you incur as a result of losing that resident. But if we're still within the eviction ban, there's nothing you can practically do to get somebody out to accommodate that situation. If we had someone back in February who wants to move in May and we were renovating the apartment, can we finish the renovations? Is this considered an emergency? It's only going to be considered an emergency, and technically you can only be completing those renovations if the person who's moving in is in an urgent situation. You know, yeah, what's an example? Because we can't force somebody to leave. Let's use an example of, you know, we know that the township has condemned the building and everybody is going to be physically removed by May 31st. And they need this place to live. In that case, I would say renovating the apartment to allow for that movement is probably appropriate. But if it's just a resident who's in another apartment who would like to move out in May, you know, I would say that the renovations at this time is not part of the emergency or urgent scenario. Should we be notifying scheduled move-ins that they cannot move in or trying to push them back? I'd be communicating, absolutely. I would be communicating with people now to tell them, you know, this is the situation. We'll update you as we can, but at this point, we don't have any more information other than at this point, at least until April 30th, nothing's happening. If the shelter continues, we have someone who is scheduled to move out and does, am I understanding correctly that we cannot release the apartment or home unless it's an emergency, and can we turn it over? Yeah, that's correct. The deal that we have with the governor is that leasing and putting people in homes can continue, but only on an emergent emergency or urgent basis. We had a tenant who's asking for security, for example, cameras and outside entrance locks. We already have cleaning and sanitation procedures in place for common areas and laundry rooms. However, we do not plan on adding cameras and locks. Is this something that they can make us do? I can't think of a scenario when a tenant would have the ability to require you to put security measures in place that you don't already provide. If you are already providing security measures, you should make sure that they're still being provided and they're being provided adequately. But if you don't currently have security measures in place, then no, I don't think a resident is going to be able to require that you do that. What are the details of the ban the city of Philadelphia has for evictions? How does it differ from the PA Supreme Court? I can't answer that because I haven't seen the actual language. So I'm sorry, I can't answer that. Due to COVID-19, we are not allowed to charge late fees or non-sufficient funds for the month of April 2020, just confirmed from my manager. That's only if you fall under the CARES Act. If you're a market property and you don't have that federal dollar coming in, then you are entitled to charge late fees and non-sufficient funds for April and for as long as this process continues. It's just those who fall under the CARES Act that cannot do that. On the building maintenance order released on Sunday, do you have to hire security if you did not have security? No, you do not. The order specifically says, and I'll read the direct quote, provided the security employees are otherwise available ensure that the facility has sufficient number of security employees to control access or enforce social distancing, provided security employees are otherwise responsible for enforcement. So if you don't already have them in place, you don't have to hire them. Are you able to do rent increase letters? Our community does not fall under the CARES Act. Yes, absolutely. The rent increase process, renewal process, that all continues business as usual. Whether the tenants are going to pay the increased rent is another question, but presumably if you have good tenants who are already paying their rent, they're going to continue to pay the increased rent. If the tenant wishes to move in and already has an executed lease but would not be an emergency move-in, are they still allowed? Again, it's got to be an emergency or urgent, or you're not supposed to be moving people in. On a HUD loan property, we had an LT filed in March. Hearing is scheduled for June 9th. Can we have the hearing that day, or must we ask for a hearing date past July 27th? Let me pull up the CARES Act, because the language says that you may not make, cause to be made, or file anything to institute a legal action. So no, I would say if it's already scheduled, I don't think that you have to reschedule it because it's already been scheduled. However, you will not be able to get them out beyond the July 27th date is my guess. Can you please advise again on the list of criteria for assets that are covered under the CARES Act? I don't have a list that I can provide. What I would say is pull up the CARES Act. It's section 4027, and it defines precisely what is a covered property, but it doesn't have a list of all the various programs. So the definitions are somewhat broad. So you'll need to just look at that broad list and see if there's if you fall under it or not. And it looks like that is the end of our questions. So thank you, everybody. I hope
so Steve, can you move to
and I'll
the
turn it back over to you, Judy.
Can you move to that additional slide that has our links on it?
Yep, there's just a little delay when I go to the questions. So give me a second here. Okay. So there's my contact information and there's your resource page.
Right. So thank you. Now, I think there's still one more question if you want to answer that, and then I'll thank you for being with us.
I didn't see another question. Oh, okay, here we go. If I'm holding a deposit for a May move-in already, and it's not per se emergency move-in, and some renovation work is required, such as replacing, do we halt the move-in? Yeah, I would halt the move-in if it's not truly an emergency. I don't think there's any way around that.
Okay, so thank you, Steve, for spending the morning with us. This has been invaluable information. We've posted our web pages, as you can see on the screen. Go there for updated information on best practices in our industry, and check our website for other webinars relating to the coronavirus. We're having another webinar on the 22nd on virtual leasing. which I think will be very interesting. So we thank you all for coming today, and please stay safe and stay healthy. And thank you, Steve.
Thanks, Judy. Have a great day.